Let's wait a minute and let everyone get settled. Okay, Ms. Stratton.
May it please the court. Under Louisiana law, when an agent is actually authorized to bind his principal to a contract, the agent doesn't have any rights or obligations under the contract. The principal is the sole counterparty from the start. Here, the Franco parties could not have contracted with Conrad as HMS's agents because they undisputedly had rights under the contracts. They were to take ownership of the boats such that they would have an option to later sell or lease them to HMS. They likewise had contractual obligations, which they later attempted unsuccessfully to assign to HMS, nonsensical if it were the already bound contractual principal. In sum, the conceded commercial arrangement in this case does not legally qualify as an agency transaction, and HMS's status as the anticipated customer of the Franco parties does not convert it into a principal liable for the Franco parties' contracts. I'd like to begin with the central issue of actual agency authority. No one disputes that Harley Franco needed authorization from HMS's bylaws or board in order to bind the corporation to a $20 million vessel acquisition from Conrad. And Conrad and the Franco parties argued below, and they continue to argue in their briefs to this court, that Harley Franco received that board authorization in his board approval memo. And we concede for purposes of argument today, the board approval memo, or the BAM, was fully approved. The BAM is legally irreconcilable with agency because it proposes clearly and unambiguously two transactions. In the first, expressly, Harley Franco as an individual through personal LLCs would acquire boats from Conrad. Then, in a follow-on transaction, Harley Franco, at his option, could elect to sell or lease the boats to HMS. And the Franco parties and Conrad both concede in their briefs that this was the structure of the BAM. If, as everyone agrees, the board approved HMS buying or leasing boats from Harley Franco and his LLCs, that forecloses an agency finding. If Harley Franco had contracted with Conrad as HMS's agent, he would have acquired no boats that he could then sell or lease to HMS. HMS's true counterparty on the contracts would have acquired the boats directly from Conrad. Harley Franco could not sell or lease something to HMS in the future that it would already own if Harley Franco had contracted with Conrad as its agent.
Is it irrelevant that there'd been decades and over 20 boats built under these Franco entities that didn't even have employees? And then HMS is essentially, and that may be the key word, saying this is how we get our boats built. And then the press release, and you've seen all the things they point to, the press release and the VP and the payments all seem to be direct relation between HMS and Conrad.
I'll take those in parts, Your Honor. I'm glad that you brought up the history because the history between the parties actually underscores the lack of actual or apparent authority here because the prior transactions weren't agency transactions either. At record 8023, Harley Franco averred under oath exactly what had happened historically, and he admits it again at page 4 of his brief. What happened historically was what was proposed and approved here. Harley Franco testified, I historically took on the business risk and used my personal credit through personal-owned LLCs to acquire boats from shipyards, such as Conrad, that I would then later sell or lease to HMS. And, Your Honor, the evidence also showed that historically the only way HMS was directly liable to pay Conrad for boats was if it decided to accept an assignment of the Franco LLC's contractual obligations. And so the history here, the only thing the history could have taught Conrad was that for HMS to be the party liable to pay it, it had to take an assignment of the Franco LLC's contracts, which is why you see in the record when Mr. Franco defaulted on his payment obligations and Conrad is emailing vigorously, it's your personal obligation to pay us, why aren't you paying us? Then they start seeking an assignment unsuccessfully. And agents who contract for their principals don't have a contract under Louisiana law to assign to the principal. The principal is already the counterparty. And so the assignment evidence, which I'll point out, we said in our opening brief it was fatal to Conrad's contentions of apparent authority, and Conrad is silent in its response brief on the issue of assignment. And so
The verdict in the end wasn't clear as to whether it was actual or apparent, is that correct?
the verdict form there's a single interrogatory that asked the jury if there was evidence of actual or apparent authority, and the jury answered yes. And so it's unclear whether
You would say to decide whether it's actual, we've got to focus primarily on the BAM?
Yes, and I would go further and say exclusively on the BAM, because Harley Franco was very clear at trial, Your Honor, and I'll point you to the record citations. 5271 to 72, 5276, 5291, and I'll also point you to the parties' briefs, Conrad's brief at 36, 41, and 43, and Franco's brief at 11 and 31. The contention in this case, Harley Franco said, quote, the only way this project could start was the BAM. His contention all along was, I had express authority to bind HMS, my corporation, to a $20 million vessel acquisition with Conrad because the BAM gave it to me. And you can't get there looking at the BAM. He told Conrad at 5271 of the record, he testified, I told Conrad I had an option to sell or lease these boats once they were constructed.
When I look at the language, isn't it open to the notion that it's mandatory? I mean, the only two options are these boats end up with HMS.
Even if it is true that we have to take the boats from Harley Franco, should he elect to exercise that option, we have to either buy them from him at his option or lease them. That doesn't change the fact that the first transaction proposed in the BAM, the transaction between Conrad and Mr. Franco personally, can't be an agency transaction. There would be nothing for him to convey to us or lease to us.
But the second sentence, they only end up with you, and I think it's undisputed, these boats were only built for your client, the P-66.
That's true. We are the anticipated customer of the Franco project.
And there is no other customer that's
Contemplate. But I think under the plain language of the BAM, Harley Franco could have at his option chosen to dispose of the vessels elsewhere.
How's that?
Because he has an option on page...
On completion of construction, Franco would either option to basically lease it back or to sell it.
I think that option there means he has an option to sell or lease. He testified that this was different from the past where HMS had the option to take it from him if they wanted to, but that HMS wasn't required to. We'll concede the point that if Harley Franco had said, I'm ready to sell or lease the boats to you, we would have been obligated to buy them from him or lease them from him. But that's different from saying we are obligated to buy them from Conrad, with whom Harley Franco alone has a contract and payment obligations if Harley Franco defaults on his contract.
So what about just the evidence that the district court points to, sort of like the VP Carlson, saying this is our project, it's not his? What's the significance of that?
That's important, Your Honor. Mr. Carlson testified that he was not involved on the contracting side of things. And so he essentially admitted his perception was that these boats were for us, but he wasn't aware of the contractual nuances. And he was not a member of the board. He wasn't aware.
Wouldn't that go to apparent authority? How would Conrad not have had the identical perception?
Because Conrad was involved on the contracting side of things. Conrad knew things Steve Carlson didn't. Here's the list of what Conrad knew. It knew, and it concedes it knew, that HMS was going through a refinancing and could not afford a $20 million vessel obligation to Conrad. It knew because it was told that instead Harley Franco, through his personal LLCs, would be the entity contracting with and paying Conrad. It knew because it was told by Harley Franco at 5271 and 72 of the record, you can see that Harley Franco had an option, once he bought the boats from Conrad, to sell or lease them to HMS. It knew what its contract said. Its contracts are with the Franco LLCs alone, signed by their manager, Harley Franco. The jury rejected the notion that these entities were a single business enterprise with HMS, so they're looking at contracts that don't obligate HMS to pay it or don't mention a theory of agency, that the Franco LLCs are contracting as agents. And they also, they also showed not just a lack of reasonable reliance, but I think no reliance at all, because they have no response to their contemporaneous documents showing them demanding payment from Harley Franco personally and seeking an assignment to HMS. That's not the behavior of someone who believes that HMS is already and has always been their true contractual counterparty liable to pay. They understood HMS's payment obligation was going to be to Franco.
So your argument is it that Conrad knew, even over all the prior decades, the 20 boats they built, that those were being built for these LLCs and not for HMS? The construction contract was with...
Yes, the construction contracts are with the LLCs. Yes, the boats are being built ultimately intended to be used by HMS, but that's different from saying that they're responsible to pay Conrad for the boats when they have no contractual privity, and there's a follow-on transaction where they're paying the putative agent, which would make no sense if the initial transaction is the agent contracting in the shoes of the principal. In that sense, the principal just acquires the boats directly from the agent. There could be no follow-on transaction. So a theory of agency is just...
I asked too many questions, but
no, I welcome them.
What's the Louisiana law that says the actual authority's got to be in writing? If it's not in the BAM, it can't exist. Or is that not your argument?
That's not our argument.
So what is the law? How do I understand whether the parameters of actual authority?
Okay. The Louisiana Revised Statute 12:1-841 makes clear that a corporate officer has only that authority that is vested in it by its bylaws or its board of directors. And we've never contended that there could not be an oral transmission of authority here. But Mr. Franco never contended that he had an oral transmission of authority. His contention was always that he had, in fact, received an express written conferral of authority when the board voted to approve the BAM. And so that's the only source of authority that could possibly exist in the record. So you're looking at 12:1.
And if you convince us that there isn't actual authority on that sort of analysis, then why wouldn't the jury actually have been ruling that there was apparent authority based on this long-standing relationship and all the communications that are outward-facing to Conrad?
And the jury, my personal view of the verdict form is that the jury likely did believe there was apparent authority. The problem there, though, is that the jury likewise did not have a legally sufficient evidentiary basis. And that's for this reason, Your Honor. We will concede, for purposes of argument, that HMS made manifestations suggestive of agency authority. But as Conrad admits in its brief, the Louisiana law requires more for apparent authority. It requires reasonable reliance on those manifestations, and a third party cannot reasonably rely when the totality of the circumstances are such that would cause a reasonable person to investigate.
But I thought they were getting money directly from HMS. They're getting the winches directly from HMS. Aren't those pretty good indicia?
Harley Franco admitted at trial that, and just to clarify, Harley Franco transmitted that money and he transmitted those winches, and he admitted at trial he had no board authority to do so. And additionally, that's conduct of the putative agent, and this court held in Richard Sheremy that a third party cannot rely upon the words and conduct of the putative agent to establish apparent authority. It must be a manifestation of the principle. Your Honors, as my time draws to a close, I'd urge the court to consider the potential impact on ordinary commercial expectations if the evidence here is deemed sufficient to sustain an agency finding. Consider, for example, the oil and gas industry that you heard about.
Objections to interrogatory number 3 in the jury charge.
I'm sorry, Your Honor.
What were your objections to interrogatory number 3 in the jury charge?
Can you remind me what interrogatory number 3 was, Your Honor?
I'll be pleased to. Do you find for preponderance of the evidence that Franco Marine and Franco Marine 2 were Harley Marine Services agents? Answer for the jury, yes.
Our objections is that that agency could only be established if there were actual authority to bind.
My question was, what objection did you make at the time of the charge?
I don't believe we objected to that question, Your Honor.
Okay, thank you.
I'd like to just point out, Your Honors, that it's common in the oil industry for example, for a major oil company to need a ship for its operations and to contract with a drilling contractor to supply it, and the drilling contractor in turn contracts with a shipbuilder. Everybody knows this ship is ultimately for the major oil company, and for that reason, the oil company might supply some designs for the ship. It might send representatives to the shipyard. The shipbuilder might excitedly issue a press release. We're so excited we're getting to build a ship that's going to be used by Chevron or whomever. But no one in that industry thinks that that makes the major oil company liable on the drilling contractor's contract with the shipbuilder. How could the drilling contractor have anything to sell or lease to the shipbuilder? In that context. That upsets the ordinary commercial expectations of the parties and the multi-stage transaction here. Thank you.
All right, thank you, Ms. Stratton. Mr. DeMarcay?
Good morning, Your Honors. May it please the Court, my name is Larry DeMarcay and I represent Conrad Shipyard. And based upon the panel's questions, I'm going to start with the verdict form. And Judge Higginbotham, in response to your question, no one objected to the verdict form at all, I don't believe. The verdict form was the way it was structured. The first few questions, the following questions relate to Conrad's claims against FM1, FM2, and HMS. So it was Conrad versus all three defendants here. Conrad can get to agency via actual authority, which they've conceded that the BAM here was approved. So once the board approval memo was approved, Franco was provided with actual authority to enter into the transactions of the two vessel construction contracts. As a third party, Conrad also has the ability under apparent authority to have HMS committed to the obligations of this particular agreement. That is why when you turn to question 4 on the jury verdict form, it's talking about actual or apparent authority, because Conrad could get to HMS in either mechanism. So that's why it read the way it did, and no one objected to it at that time. So when we talk about...
I mean, when you look at the BAM, it looks like Conrad would have understood that, as its own construction contract suggested, that you were building it for and being paid by Franco. So I'm not sure I agree with you that establishes actual authority. I'm very open. I mean, it sounds like the principal argument against apparent authority is that you should have looked more. Put that aside. Just, again, what exactly is what in the record shows actual agent authority?
Well, in the board approval memo,
Yeah.
if you look at the email where they were circulating it, as well as the memo itself.
Yeah, let's just look at the text of the memo, the proposed structure. Where do you see anything but this contract is going to be, they turn around and assign it back to HMS? I don't see that HMS is interacting with you directly.
That is, if they were interacting with us directly, it would be straight breach of contract,
Right.
Not based upon agency principle.
Where do you see the actual authority to buy it on behalf of them, as opposed to assign it back, lease it back, sell it back to them?
Well, that is not, that follow-on transaction that HMS is speaking of is not in the board approval memo. What the board approval memo is saying is that Harley Marine Services needs 2 new vessels for their number 1 client, Phillips 66. We're in the middle of the Guggenheim refinancing of $300 million. We can't put it on our books until the refinancing is finished. So the solution they came up with was HMS authorized Franco to move forward with the transaction on behalf of HMS, who needed the boats, to keep it off of the balance sheet.
I'm going to test you on that. I don't see the on behalf of. I see the emphasis on Franco as an individual using his personal assets would make the contract he made with you.
Then that's because they needed to do it outside of HMS to keep it off the balance sheet. But the board approval memo system of the 2 options of getting the boats back to HMS is different than the vessel investment agreement. The vessel investment agreement were some of the other vessels that Mr. Franco had.
I don't understand this keep it out of the books, because if they're an agent, they're buying it for HMS. But if you're acknowledging they had to buy it for themselves because there's no money for HMS to buy it, then why is that's inconsistent with them being an agent? They had to be a corporate separate entity.
Well, HMS had the ability to buy the boats. They needed to do it after the refinancing was over. It was more an accounting timing issue that they came up with.
But that would suggest to me, and maybe we can move past it if I'm just confused.
No, we don't move past anything.
Well, I guess if you can't buy it directly, how is it that you're buying it through an agent instead of this exact arrangement, which contemplates we're going to let these separate entities buy it, negotiate with you fully. Ultimately, HMS has the option to buy it.
And that might make, if we were truly negotiating with Franco Marine 1, Franco Marine 2, that may make some sense. But in this case, we didn't negotiate with Franco Marine 1 and Franco Marine 2. From Conrad's perspective, again, as the evidence showed, this was an HMS project from the beginning. The proposals that we prepared, 3 of them, went to HMS managers. HMS managers made the changes on the proposals. Once we were negotiating, getting closer to the starting point of the contract, they came up with this issue with the refinancing. And that's where they came up with their system. And again, we were not privy to anything in the board approval memo. All Conrad knew is they were dealing with Harley Marine Services people. So they came and said, okay, this is how we're going to do it. So Harley Franco finally says, these are the 2 entities we're going to put this particular project in. Then they wire money to us, as the record shows that the money came through Harley Marine Services subsidiary bank accounts through these 2 towards us. When they talk about Harley Franco sending us the money, Harley Franco is the head of Harley Marine Services. All of the emails show he had staff doing things. He didn't call the bank. He didn't know the account numbers. And the people that were dealing it were all in the accounting staff internally at Harley Marine Services. So Harley Marine Services people sent us the money. Harley Franco didn't send us 2 big winches.
I like that your position is there's a breach. One way or the other, there's a breach. They're an agent.
Yes.
But you didn't have internal knowledge as to know whether it was actual or apparent.
Correct.
Is that correct?
And that's where we're getting back to the jury charge. From Conrad's perspective, we don't care if it's actual or apparent authority. It gets back, Harley Marine Services is responsible either way.
Yeah.
Is the kind of perspective that we had, which is the reason that we worked on the charge, which everyone was in agreement with. And then getting back to, do you have any other questions, Judge Higginson, on this issue? I'm happy to
I've
talk.
always got questions. You should go on with your argument, though. I've only got 2 others if you have time. But
I have 3 minutes. I'm happy to do your questions.
it doesn't really matter about the detrimental reliance claim, correct? In the end, the court ordered damages only 1. Is that
Correct. It was we had 1 line item of damages. We take the position that both particular claims damages are the same. If for some reason this panel decided to invalidate the breach of contract claim but allow the detrimental reliance to go forward, there's adequate information in the record that the court could look to see how the damages were broken down as far as that stuff. And that could be found on Trial Exhibit 177, which is found in the record from pages 7531 to 7551, and the testimony of Cecil Hernandez, who is Conrad's chief financial officer and president at the time, 5474 to 5477. So if we believe that both causes of action can stand, both of them under Louisiana law are contract-based, the breach of contract claim against Harley Marine Services is based on the breach of the actual vessel construction contracts, which we get to them through the agency principles. Detrimental reliance is based upon their representations of everything that they kept telling us, that you're building the boats for us. These are for our clients. Deal with our people. Deal with our designs. We're going to put someone in the shipyard. And then once we were having payment issues, and that is when Conrad became desperate. These are $10 million vessels and no one's paying them for us. They are going to send some frantic emails trying to get paid because they were doing what was right, and they kept building the vessels on behalf of Harley Marine Services because they had done this 22 times before. This scenario was no different. And so they just kept going. And then even at the end, right before Harley Marine Services pulls the plug on these 2 vessels, which is 17 months into construction, They are still a few days earlier reassuring Conrad, the financing's coming through. We think it's going to be funded next week. That would kept
When you
us
say
in the
they,
game.
who's the they?
That would be Sterling Adelahaca, who is the Chief Financial Officer of Harley Marine Services, who at the end was the person that was reassuring Conrad that we were trying to work it out. And it wasn't until essentially Harley Franco was thrown out of his company at the beginning of 2019 or 2018 that they said we don't want the boats. Because all of a sudden Harley Marine Services had boats available because of the corporate issue that they had throwing Mr. Franco out. They lost a lot of business. They lost a lot of clients. So they went from utilizing all of their vessels to clients pulling out of Harley Marine Services. That's why they all of a sudden had all these vessels available. So the new management of Harley Marine Services said, let's not buy the $10 million vessels, 2 of them. Let's use one of these vessels that have now been returned to us because of their corporate issues that they were having. That's how we got here, Your Honors.
Right.
My time's up. I'm sorry if I went over.
Thank you, Mr. DeMarcay.
Thank you.
Is it DeMont or DeMonte?
Beg your pardon?
Is it DeMont or DeMonte?
DeMonte.
DeMonte?
Yes, good morning. May it please the court, Theresa DeMonte on behalf of the Franco parties. HMS attacks the verdict on sufficiency ground accusing the district court of cherry-picking evidence. In fact, it's HMS who's doing the cherry-picking here.
Their allegation that was cherry picking went to apparent authority, correct? That was their response to only
Yes,
to apparent
well,
authority.
and to actual. And, you know, here the cherry-picking is they now take the BAM, they say this is what it had to be, and that's the authority here, and then they draw inferences in their favor to say, well, that's not enough. All in an effort to convince this court of their version of reality. That's a version that the jury rejected. The BAM, our briefing does not say that the BAM was approved. Our briefing says that 3 board members approved the BAM and that Tobias Bachteller approved the P66 proposal, which was reflected in the BAM. And what the BAM means...
What's the strongest record support for actual authority? Because the jury's interrogatory, their answer was just, there's an agency relationship here. It's as open to an apparent one as an actual one, but it has big consequences. So what would you point to if you had to point to a single item in the record that most confirms actual agent authority?
The indicative letter, which is Exhibit 101 at 6561.
The indicative letter, okay.
The indicative letter. I would also...
And it is read out the relevant language that confers actual authority from that.
It says the contract will be executed by Conrad and Harley. There was testimony in the record, not just from Mr. Franco, but from Ms. Terrio and from other witnesses, that Harley refers to Harley Marine Services, not Harley Franco. She addressed the letter to Mr. Franco and would never call an elder by his first name, she said. And that's...
I'm just showing a little skepticism. The best authority for actual authority has to do with a reference to Harley, but that is the name Harley Franco of the person who owns the LLCs.
Well, look at Exhibit 117. That also is the proposal from Conrad to Mr. Carlson, the VP of Engineering, and it CC'd to Mr. Gullickson and Mr. Godin, and in parentheses it says Harley. They're with Harley Marine, and the subject line in that is Harley Marine Kestrels. Additionally, there's lots of record support for this, Your Honor. Look at Exhibit 103 at 6581, Bachteller saying, we looked through this last year. We discussed and approved the 2 traditional tugs for the P66 renewal. It postdates it, but that's circumstantial evidence of actual authority at the time. And Mr. Bachteller admitted that the board approved the indicative letter. It was clear as day at 5299. I'd like to really...
Yeah, but I know, but I guess their point would be, we accept the indicative letter, but the indicative letter is talking about Franco Harley.
Well, that's disputed, and again, the course of dealings with the... And I'd just like to address the indicative letter. How do we get to the indicative letter? Matt Godin writes to them and says, this is in July 14th of 2017, Exhibit 19, 5836. Hey, I'm hesitant to push forward on HMS signing the payment schedule without CAP Financing's commitment because it'll be challenging to meet if we have to fund construction. Can we add a stipulation that Conrad will renegotiate the payment schedule? And we know that, look at Exhibit 134 and 135, page 21. Mark Stifel, the VP of Contract Administration, initials just that one page, the payment schedule. Why? Because Harley Marine Services would be on for meeting those payments. And there was evidence in the record that through their long course of dealings, they would make those payments, the money would be wired, and they were aware of that.
Wouldn't that go to a parent authority then? From the whole history of relationship with Conrad, it would be logical to assume HMS is going to be the beneficiary. But none of that works backwards to say, after the investment and this sort of rift between the ownership, that actually that was an arrangement that was applied in this case.
Well, it does go to actual authority because the parties had a course of dealings that for transactions that were approved by the board, for transactions that were approved by the board, it would be pursuant to this. There would be, Mr. Franco would start the construction through a single purpose entity, and then they would guarantee to buy the lease. And if you look at, I really quickly would like to just finish this one point about the indicative letter. So he says, can we renegotiate? He said, we'll do a side agreement, and here it is. And it has 3 points in it, and that's returned to them. And Matt Godden brings this to the board, and Mr. Bachteller says, well, I'm worried about the first hit on a Google search being that Conrad has $20 million in tug orders from HMS. That's in the record at 5944. We need to do our homework and check, and we need to coordinate on a press release. Matt Godden goes back to Conrad and says, I've added this thing to the indicative letter, number 4, that we will coordinate on a press release. And then they did coordinate on that press release, and that press release was issued. And the testimony was that it went out to everyone in the industry, including—
That's the one that says this is our project, not
This
his.
is our project. It's an HMS boat. Look at Exhibit 136 in the record.
It'll end up being an HMS boat.
Well, but that was the promise, is that it will be an HMS boat. It's going to be constructed, and they will, in fact, the agreement wasn't that he had an option that Harley Franco could just keep the boats if he wanted to. No, the option was could lease or sell, had to do one of them. HMS was not going to allow Harley Franco.
Finish, but that's been a sort of problem with me for this case throughout. How can your clients claim to be an agent when the written agreements contemplate they're going to sell or lease back to another entity? How can agency ever be reconciled with an agreement saying they're going to sell or lease back to their principal? I just don't understand that.
Well, it's an agreement that's temporal, and it had to be done that way for off-balance sheet financing. And I'd direct you to Exhibit 20, which is at 5958. And Franco is writing with Grant Hughes from CAP Financing shortly before the saying that these tugs are an HMS show. He said, well, does that mean there will be a corporate guarantee? And Matt Godden writes back and says, HMS would provide the guarantees for the charter back to HMS, because that was the promise, was that they would. Additionally, that's the record on actual authority. The jury found actual authority, and that happened in question 11. If you look at question 11, and you have to construe, of course, the verdict form with the instructions, they were tasked with finding whether the jury was tasked with finding whether the down payment and expenses were within the scope of their authority. And they were instructed that if they found that executing the contract with Conrad and those contracts and related payments were within the scope of their authority, they have to reimburse. By contrast, if they exceeded their authority, no duty. The jury answered yes. That is actual authority. Moreover, the district court in its findings—
Slow down a little. So you're saying the answer to interrogatory 11 is
correct.
The most conclusive, that there was actual instead of apparent authority.
That's the jury's finding, and it's supported by ample evidence in the record.
Okay.
Including Mr. Franco's testimony that this is the way it was done and that he did have authority.
That would include the 22 other ships that had been built under this protocol.
Yes, and that's when
The variation came after they fall out, and then suddenly they shifted gears and sent it better to put in the plug.
That's exactly right. I mean, when a principal has a course of dealing with an agent like that and acquiesces, it creates, that's implied authority right there. Everyone knew that these were HMS tugs. And as far as the assignment and those arguments.
Jury charge conference, putting on my hat as a trial judge from many years ago, the one of objections. As I read from this record, out of that conference came, these were the questions that were being submitted to the jury. This is the way we're going to get the jury sort out this long history of this relationship and what the authorities were, what the parties understood the authority were. And no one objected to whether it was a parent, real, and that's what the jury answered.
That's what the jury answered, and there were no objections to these instructions or to the verdict form. This was how the case was going to be resolved. Reimbursement flows from that HMS's indemnity is foreclosed, and director reimbursement is appropriate for the reasons we stated in the record. I respectfully ask this court to affirm the district court's rulings. Thank you.
Thank you, Ms. DeMonte. Mr. Houghton for rebuttal.
May it please the court, just a few very brief points. Counsel just mentioned that there could be implied actual authority because of the parties' course of dealing in the past, and that is incorrect. There's no debate that Harley Franco needed board approval to bind HMS to these contracts. Among other places, Your Honors, on 5276 of the record, Franco testified under oath, quote, "The projects couldn't start without board approval." Second, the record makes crystal clear, and Your Honor, you understand the BAM's structure perfectly. The record makes perfect clear that the BAM was Franco's sole source of actual authority to sign these contracts on HMS's behalf, or his attempt to do so. He testified to that exactly 3 times on ROA 5271-72, 5276, and 5291. My colleague mentioned 5276. I'd like to just focus on 5291 for a second. And on that page, Franco repeatedly agreed that he signed the Conrad contracts and directed HMS employees to do some of the things that have been discussed today because of and only because of the BAM.
Do you want to speak to the indicative letter?
I do, Your Honor. Thank you. For the indicative letter, Franco repeatedly testified under oath at trial to the jury that it was a mere component of, and in his words, quote, part and parcel to the BAM. That testimony is in at least 5278, 5311, and 5318 to 5319. I believe his direct quote on that is, quote, "It is not a different deal than the BAM." And the BAM makes that plain. The BAM says this indicative letter relates only to Franco's personal financing of these vessels. It is not an independent source of authority. Conrad's counsel mentioned that HMS's CFO had promised some payment after the contracts were signed. That is incorrect. What the record shows is HMS's CFO said we are looking at financing to take on and take assignment of Harley Franco's personal finance obligations to Conrad. What this case is really about is Conrad's failure to get a guarantee from HMS, and they tried to do that in the litigation and were successful at the trial court. But what the case doesn't show is an evidentiary basis for actual authority. And what the case does boil down to is, did the BAM, Franco's only source of board approval, contemplate an agency transaction? The answer is no. An agent cannot acquire things for a principal.
Why did you not object to the charge then?
I can't speak to that, Your Honor, but there still has to be a sufficient evidentiary basis for actual authority. And here, the BAM is the only basis for actual authority. And if he's acquiring something to then sell or lease to the...
You say that's the only source of it. The course of dealings with the parties, over 22 vessels, strikes me as a great deal of history against which you read that single document that you're talking about. Suddenly, you switch gears and so forth. Whether or not the jury answered against you straight away down the line. They didn't buy any of that. So I have a lot of confidence.
That's right, Your Honor. The jury answered yes. There was...
Submitted to the jury.
Your Honor, the jury did answer yes. There was actual or apparent authority. They didn't distinguish between the two. And course of dealing under Louisiana law is not sufficient to create actual authority. That's a civil code article.
You're saying you didn't object to that charge because if there's apparent authority, you still get indemnified.
In the event the court finds that there is only apparent authority, HMS would be owed indemnity from the Franco parties. That's correct, Your
That might
Honor.
be a reason you wouldn't object, although it would have added clarity. But what about their focus now on the 11th interrogatory?
The interrogatories relating to the reimbursement are interesting because the jury expressly found there were 0 damages. I think the jury wrote in none on the damages the Franco parties were owed due to the reimbursement. So if anything, I think the court should find that the jury's finding of no damages for the $2 million in reimbursement shows there was no actual authority. That's how I think you square the jury's interrogatory, even though we don't even believe that there's a sufficient basis for apparent authority due to the reasons that my colleague explained. And just to close, as I mentioned, this case is about the corporate guarantee from HMS that Conrad admitted at trial it didn't get. Neither the jury nor the court had a legally sufficient evidentiary basis to find actual authority, and we would respectfully ask that the court reverse. Thank you. Pending the court's questions.
Thank you, Mr. Houghton. Your case and all of today's cases are under submission, and the court is in recess until 9 o'clock tomorrow.